So people have misconceptions about what estate planning is and who should really do it. Estate planning is basically the process by which you choose where your stuff is going to go and who's going to be in charge if something were to happen to you and you decease. Obviously, all of us are going to die someday, so best to get it taken care of while you're young and healthy enough to pick who you want to be in charge. The nice thing about it is you can always change it at any time. So a lot of times I'll have a young couple come to see me, maybe they have their first child, and they want to make sure that they have control over who would be the named guardian. So a guardian for a child is the person who actually has the care and custody of the child if something happens to the parents. So that could be a trusted relative, friend, whoever would be the best fit. There's also a conservator that you can name over your children, so a person who would be in charge of the finances. Oftentimes we ask that people try to split that up between two different people. That way there's no appearance of impropriety or issues with somebody feeling like they shouldn't be using the money to take the kids on vacation or do something like that because they think maybe it looks bad since they're the ones that are caring for the kids. So that's something that a lot of young people want to do, is name that proposed guardian and that proposed conservator for their kids. With estate planning, there's basically three different types. You can either do joint titling, which means that both of you guys are on everything. So if it's a husband and wife situation, you're both on the deed to the property, you're both on the title to your car, you're both on your bank account. The problem with joint titling is it's not foolproof. With joint titling, if both of you happen to decease or become incapacitated, there's an issue. So joint titling does work in certain situations, and it's one of those things where we look at each individual client and what they have going on in their lives at the time that they're doing their estate plan. And again, you can always change it later. The second way is to do a will. In Michigan, you can't have a joint will. If it's a husband and wife, you each have to have your own will, and in that will you name a designated personal representative. That's basically the person that would have the legal authority to act on your behalf once they have been appointed by the court, using your will to get appointed to be your personal representative. So the will is a document that says who you want to be in charge, who you're nominating, and where you want your stuff to go once that person does get appointed by the court. The issue with estates in Michigan, it's very expensive. It can be very time consuming. It takes a long time for the court system to work. Informal probate is where basically your personal representative files all the paperwork with the court, but they never have to have any in-court hearings. That's how most of the estates go if there's a will. And there's also formal probate, where it's more, obviously more formal, and you have hearings about the acceptance of the petition to have the estate opened, that sort of thing. Sometimes when you have a personal representative that's an attorney or a bank or something like that, they do the formal route just to make sure that everybody is aware of the proceedings and what's going on. Another issue with the going the will route is in Michigan, there is the issue of having the estate be gone against by Medicaid if you're ever to receive Medicaid. If you're a recipient of any Medicaid and you have a probate estate that's opened in your name, the state of Michigan can come back as a creditor to get paid back for the money that they put out for your care. The other issue is there's estate inventory fees. So the state of Michigan takes a percentage of the total inventory of your assets, and it must be paid before the estate can be closed. There have been times where we have an estate that is just real estate, and if it doesn't sell right away, it can be very problematic because the heirs have to cough up the money to keep that house going, to pay the utilities, to pay the property taxes, all of those things. And if the house doesn't sell in a timely manner, then they may actually lose the house if there was a mortgage on it and they aren't paying that mortgage. So it's a very touchy situation when you're doing an estate through the probate court. The third way is to do a revocable trust agreement. There's also irrevocable trust, but that's a topic for a whole nother day. Revocable trust agreements are basically like setting up a family business. You take your assets from your left hand and you transfer them to your right hand. Your family business is, for example, like the Davis Family Trust or whatever you want to call it. And in that trust agreement, it's a contract. You lay out who you want to be your trustees, which is typically the husband and wife during their lifetime. And if something happens to the husband or the wife, the other survives, they would remain the sole trustee. They're also the only settlers, the makers of the trust, the owners of the family business. And being the settler of the trust means that you have the ability to change anything about it during your lifetime. So you can change who's in charge, You can change the terms of the trust, who gets what, under what circumstances, that sort of thing. Once you pass away or you become incapacitated, in your trust you have named a successor trustee or co-trustees. And that person then steps into your legal shoes to be able to administer the trust the way that you have it laid out, to kind of follow through with the contract. Once both of these settlers, the makers of that trust, have deceased, the trust does become irrevocable. At that point, the trust gets its own federal tax ID number through the IRS, and the successor trustee then is the one who basically coordinates to get all of the assets marshaled, to get them sold if that's what the trust calls for. Sometimes trusts are meant to last for a couple generations because there's maybe a family farm that the settlers didn't want to be sold right away, or that sort of thing. But the beauty of having a trust is that it stays outside of probate court. So there is no public inventory that is seen. It's all a very private document. So your successor trustee, upon the death of both of the settlers, sends a copy of all of the paperwork to all of the heirs and the named beneficiaries. If nobody contests anything, which is usually the case, then the successor trustee is able to start dividing the assets the way that the trust has laid out. There's lots of different ways to set up your distribution section for your trust. If we say the common way or the usual way is to have it go maybe equally to all of your kids. A lot of times though, if there's adult kids and then there's grandkids, depending on the size of the trust assets, my clients will choose to split it up where there's a percentage that goes to the kids, but then a percentage that goes to the children. The reason being, if all of your adult kids survive you, right? We all hope that they do. If something happens to them shortly after they have received their portion of the trust assets, if they're married and they don't maybe have their own estate plan set up, or they do and it's set up that everything goes to their spouse, the money that you would have left, or the assets you would have left to them, could be going to their spouse instead of to your children. So a lot of times people want to make sure that they keep it in their branch of the family tree, so to speak. Another issue is if you leave it all to your adult children and don't leave any to the grandchildren, your adult children could run into creditor issues, bankruptcy issues. They could get in a car accident and get sued by somebody, and any money that they have inherited from you could be subject to their creditors. So a way to avoid that is to give a percentage to the grandkids and then make their parents the conservators, the trustees of that amount. But then it keeps it from the spouse having access to it, and it keeps it from any of the parents' creditors from having access to it. So that's one way to kind of make sure that there's some longevity to whatever benefit you're going to leave your heirs. Something else to think about is when you leave anything to minor kids. When I say minors, in the state of Michigan, it's considered 18 and under. You're a minor. So if you don't specify at what age they're going to be able to get these assets, they may get them right when they turn 18. Now, I remember myself when I was 18, probably wouldn't have been the best person to be in charge of any substantial amount of money. You're young. So one of the things that I recommend is what I call kind of a hybrid. It says that until your grandkid or your beneficiary, your kid, for example, if it's a young couple, until that person reaches age 18, whoever you chose to be in charge of their finances, that trustee, would be able to use that money for any of their needs, wants, and comforts for the lifestyle they're accustomed to. Kind of broad language to say whatever the trustee thinks is an appropriate use of the money. It could be school clothes, it could be living expenses, it could be a study abroad program or a camp or something like that. Once that child turns 18, then the spending stops as far as the free-flowing spending, and it switches to just be under emergency circumstances and the trustee's sole discretion, or for educational expenses. What that does is then up until the next age that you choose, which I typically say 25, 18 to 25, whatever is left in that child's portion of their inheritance is still accessible, but only for the educational or emergency purposes and that trustee's sole discretion. By doing that, it cuts off that broad discretion and keeps what I call like the bratty 19-year-old from coming to the trustee and saying, hey, if it says needs, wants, and comforts and I really want to go on spring break with my friends, write me a check. Not acceptable. So if they've made it to 18 and they want to do the fun things like that, they can go get a job and pay for it themselves. but your parents' inheritance that they left you or your grandparents' inheritance that they left you is to be used for educational or emergency expenses. Sometimes I have clients that choose to put a bit more broad language in there, and maybe they can use it for a down payment on a house, or they can use it for starting up a business or something like that. Again, whatever my clients desire to have in there, it's their money. They can do what they want with it. They can spend it how they want. They can save it how they want, and they can direct how it's used to an extent. So it really is a case-by-case situation. One of the other things, though, that I recommend if you're doing these is to put in a clause that says if there's any alcoholism, drug addiction, mental incapacitation, something like that, that's causing one of the beneficiaries to not be able to financially manage their inheritance in a prudent manner, that the trustee could extend that until a time that they see fit. That could be, maybe they're just having a situation with addiction, and at 25 years old, it would be a very bad thing to be giving them a chunk of money that might go to feed that addiction and cause major issues. So I try to put some language in there that gives that trustee the ability to kind of manage that for a little bit longer if needed. Obviously, there could be a situation where that beneficiary is going to go to court and file a motion and say, hey, the trustee is not doing what they're supposed to be doing with this. But that gives the trustee the out of saying, look, okay, if the judge says that they think that you're okay to manage this, then I guess it's not on my hands anymore. So again, the 3 ways to estate plan: joint titling, make a will, and take it through probate, or do a revocable trust agreement. So again, this is specific to Michigan. So unfortunately, some of you that are watching are not from this jurisdiction, so it might not be super helpful. But some of these tips and tricks can be applied to any jurisdiction, really. So hopefully it helped you. Thanks so much.